The next case on the docket for today is SS Adoption of E.J.S. versus Department of Children and Families. Counsel here on both sides of that case.
Go ahead. Judge Orfinger, Judge Palmer, Judge Eastbound. Good morning. I'm Richard D'Amico, Daytona Beach, Florida. I represent the appellant, Civil Civic. As you know, the facts of the case are fairly simple. It's a fairly simple record. There was no evidentiary hearing. There are no findings of fact. It's mainly a pure issue of law that we're dealing with, I believe. As you know, my client filed a petition to adopt a child. She did not have the consent of the department. The department does not consent to this adoption. However, in her petition, she alleged that the consent was being unreasonably withheld.
Why isn't this case controlled by Buckner?
Judge, this is why we're here. I believe, and we're asking you to recede from Buckner, that we think that Buckner and the IB case conflict, and we also think that the BY case that came down from the Supreme Court has clarified that issue. The consent of the department is now no longer an absolute requirement.
No, I don't disagree with that. I think we all agree with that position. I guess the question that I have, though, is, factually, there seems to be a big difference between IB and Buckner. In IB, number one, the foster parents at the time that the filings were made were the current foster parents. They had custody of the child. And further, they alleged that there was a specific agreement between themselves and the department to adopt that particular child. That's the facts of IB. Buckner is a completely different situation. You've got a former foster parent, which is more akin to what we have here. I mean, as I recall, this child hadn't been in the custody of your client for, I don't know, was it a year or so? I forget exactly.
That's correct.
I forget the time frame. But so I guess I'm just wondering why, at least on their facts alone, IB and Buckner aren't distinguishable.
Well, first of all, I was the attorney on IB, and I know the case pretty well. And
sadly, I do too. I was involved in a big part of IB.
Well,
and so I know more about it than I really would like to.
I know, but the issue that you're raising in distinguishing these two cases is actually even stated in IB that I'm trying to find it here where I think it was said that, get my hands on it, even if there were no such agreement, the agreement you're talking about, the child lived with the foster parents for 16 months, which violates the statutory directive that foster care be limited to 1 year. In addition, the child had bonded with them, and they were the only parents that the child had ever known. Now that's what. So what they were basically saying was there may have been some agreement between the department, but you can't have an agreement to adopt a child, in advance. I mean, it's not something that's even legally enforceable. The real question, and what we're asserting and what we're arguing, is that the best interest of the child should always control in every one of these cases. And I could give you a number of examples. For example, here's the case that gives you the example right here. In this Civic case, she brings a petition to adopt the child. The department says, absolutely not, we're denying your petition, we don't consent to the petition, you're never going to adopt this child.
Let me ask you this, because it seems to me that the threshold question under the adoption statute, and I grant you that the adoption statute is pretty broadly written and says something to the effect of, any interested adult can file a petition for adoption.
We argue that in our brief?
And I grant you that you argue that position, but don't you think that when it says interested person or interested adult, it means something more than just having a passing interest in the case, that it's more in the concept of legal standing as opposed to, I think as a general proposition, most of us are interested in the general welfare of children in society. I'm interested in the welfare of children. But I'm not sure that that would give me the right to simply go to the department and say, I understand that you've got, little ABC in parental rights have been terminated, little ABC, and I'm interested in having a child, and I'm also interested in the welfare of children, so that gives me a legal interest.
I agree with you 100%, Judge, but that's not the facts of this case. And I can give it to you because this was a case where there was a dismissal without a hearing. There was no evidentiary hearing. The judge dismissed it right from the petition. Now and there was a motion for summary judgment that was made. The motion for summary judgment was denied by the judge. And she said, on the record, it's in the transcript, this is a best interest determination. The day before the hearing, she canceled the hearing. It was June 2nd. I know that. It was my birthday. The day before, we got a fax that said, this hearing is canceled, okay? And I'm going to get into this a little bit later about why I think there's some confusion with the judge. But listen to the allegations that were in the affidavit that's on the record in support of the motion for summary judgment. This is why the Buckner case can't stand, okay? In September of 2004, James was transferred to the home of Peggy Kuhlman, where he initially improved his bedwetting. However, after a couple of months, he started to deteriorate. The bedwetting increased to the point that Mrs. Kuhlman was unable to handle him. Next, in December of 2004, James was moved to another foster home where he was sharing a room with a 15-year-old that had allegedly been moved 30 times in the past year for severe behavior and allegedly had a sexual abuse history, okay? Then the guardian says, it appears to be a vendetta that the department has against my client, not that the department's looking for the child's best interest. Then she goes on to say, James has totally regressed since being moved from Mrs. Civic. The child strongly desires to be adopted by Mrs. Civic. And then it says that this is the only place in which the child has thrived has been the home of my client. Now, the judge did not get to hear that evidence because she dismissed the petition. Now, if your position is that a person who's had this child for 16 months, the guardian ad litem, who's an impartial third party, has all these concerns about this child, that you don't have the right to go into a court in the state of Florida and have a judge make a decision, I think is wrong. And I think Buckner...
Counselor,
yes, sir.
in terms of, we need to back up a little bit, and maybe you can help me out here. Wasn't there an order on August the 30th, 2004,
Yes.
which, by that judge, which removed your client as being the foster parent?
Well, that's not exactly right. The department removed the child.
I understand, but didn't the court affirm that?
That's correct.
And then wasn't that issue appealed?
Yes.
And the allegations, whether you agree or disagree, the trial court used that found that basis to remove your client as the foster parent.
Correct.
And that was appealed, and this court, the Fifth District Court of Appeals, affirmed, correct?
Correct.
All right. Now, this child has been out of your client's custody for how long now? 23 or 24 months?
Judge, that is correct.
All right. Go ahead.
Now, let me respond, because I knew this issue was going to come up, and you need to understand it. What happened was that this child was a problem child, bedwetting, all kinds of behavior problems. They placed this child in the home of my client, who, by the way, is a member of the bar. She took such good care of this child that the trial judge, in the order that you just referred to, said she took very good care of him, and he was happy. Up until the events relating to his October 2003 removal, his condition improved in her care in every measurable way. Now, this is who we're dealing with, and what happened...
Up to that event.
Right.
And the trial court had some evidence before it
Right.
from which it could find that, A, injury was inflicted on this kid,
Correct.
B, it was done by your client, and C, she showed up smelling of alcohol at the hospital with the kid. Is
The
that
actual
correct?
findings were that she did not, okay? This happened at night, okay, while the child was asleep. He woke up, and he was having a problem with his eye, and she took him to the hospital. This was not a complete evidentiary hearing. There's no there is nothing in that order that says that my client inflicted this injury, and, you know, I think it's almost impossible. But let me just continue.
But wasn't there some evidence or some finding that it wasn't self-inflicted?
That's correct. But he's a child. It could have happened at school. He could have hurt himself, went to bed, and woke up in the middle of the night with his eye. I mean, we don't know what it was.
Let me back up to some more basic questions. Is it your position that in order for you to prevail in this appeal, we have to recede from Buckner? That not that it's distinguishable, but that it's bad law and we have to recede from it?
I know you two were on the panel on Buckner, and I'm glad it is you, because we can discuss it. I think Buckner has effectively been reversed by BY, effectively. Because when you referred to the BY case in Buckner at the DCA level, the BY case was a case where a judge had an adoption hearing. The department came to the hearing and said, we do not consent. And the judge said, I don't care that you don't consent. These children need to be adopted, and I'm adopting them right now. The department appealed, and the DCA reversed the trial judge and said, no, the choice of adoption is firmly reposed in with the department. Well, that was appealed to the Supreme Court, and the Supreme Court said no. That if the trial court finds that consent has been unreasonably withheld, then you can go forward with an adoption. And
Who can go forward with an adoption? Anybody?
Well, I mean, here's a person who had the child for 16 months.
No, I know about, but we have to deal with cases that draw the line. So let's see how far you. Clearly, you say a former foster parent who had the kid for 16 months would be enough.
Yeah.
Where do we draw the line? If I had the kid for 3 days in shelter, do I have standing to come ask to adopt and can argue if DCF unreasonably withholds?
Well, you know, I guess we could take those case by case, but why not? Why are we so afraid about having hearings? I can understand we don't want strangers to come in off the street and adopt children. I do understand that. But anyone who has had, you've got to understand, these foster parents have much more contact with the children than the department. The department makes a 1-hour visit.
I'm sorry. Anyone who isn't a stranger, is that what the legal text should be for us?
I think
we have to deal with the principles that can apply to more than just this case. So how would you articulate what would be required for someone to have standing?
Well, that's why I was going to IB, because IB defines it, because it talks specifically about standing, okay? And it says that the matter of litigation was the placement for adoption for the foster parent's child who they wanted to adopt and had cared for the past 16 months. The foster parents would directly gain or lose by the court's ruling. The foster parents have sufficient interest to warrant intervention in the litigation. Right in the IB case, they talk about standing, and it's the same period of time. It's 16 months in both cases.
But don't you think that there's a distinction between current foster parents and former foster parents?
I could see you wanting to go that way, but you have to resist it, and I'll tell you why, because I'm going to give you an example. Let's take this particular case, Civic, okay, where instead of him going to 3 failed placements after Mississippi, let's say he was in 10 failed placements, 20. Let's say they moved the kid every week, and he said, I want Civi, okay? Under your ruling, under the direction you're going now, she would never be able to adopt the child. She couldn't even get a hearing. Now, that's where the problem lies. This guardian ad litem, I mean, if you read her affidavit, it's unbelievable, okay?
Let me ask you about another case that you may or may not be familiar with, a case called Lofton versus a federal case called Lofton. And one of the holdings in that case dealt with an attack on the Florida statute that prohibits homosexuals from adopting. But one of the holdings of the 11th Circuit in that case was that foster parents and legal guardians seeking to adopt foster children with whom they've formed strong emotional bonds have no due process protected liberty interest in family integrity entitling them to some right to adopt.
I agree.
Now, we can argue about whether that's good policy or not, but the question is that the law of Florida?
Well, first of all, I think the law of Florida is set forth in the BY case, which is that you can adopt and without the department's consent if the consent is being unreasonably withheld. But to answer the question,
But before you ever get there, don't you have to have standing to bring the complaint?
Judge, go back to the example I gave you. Let's say, you have a person who's developed a 16-month relationship in this case, okay? If that's not enough, and a guardian ad litem who's saying that the child has bonded to her, is that not enough? Is that what you're saying?
No, I'm suggesting to you that the department may make a bad decision. I certainly am not going to defend the department because they make some good ones and they make some bad ones. What I am suggesting to you, though, is from a standpoint of standing, which is you got to have standing before you can walk through the door of the courthouse.
Okay.
If a foster parent who had possession or custody of the child for 16 months a year ago has standing, what about Judge Palmer's suggestion? Is someone who had shelter custody for a week, shelter custody for 3 weeks, custody for a month? Does anybody who has, if I'm just generally interested in the welfare of children, the kid lives next door to me, and I know the kid really well because he's lived next door to me for 5 years, and I think that I could provide a better home, do I have standing?
I understand your point, but the thing is, you can't cut it off at the knees. Whatever the standard is going to be, you can't cut it off at the knees and say, well, you haven't had this child for a year, so therefore you're out of the picture, okay? You have to at least give the person a hearing. The judge has to have a hearing on the issues as they are now. Because getting back to Judge Griesbaum, I didn't answer your question completely. We got sidetracked a little bit. That things change. Now, in this situation, you talk about the prior case and the prior order, okay? Well, my client denied ever hurting the child. And then a year and 2 years went by. They hadn't placed the child. He was in the gulag of foster care at that point in time. So for her to come forth and say, look, we have cases in dependency all the time where parents are sent to, like alcohol treatment or drug treatment, and then they come back into the child's life. There are some children that are going to be very difficult to adopt. So, right now, as far as the cutoff goes, how can a person who's had a child for 16 months and has the glowing report of that guardian ad litem not be entitled to a day in court? That's the question. Not be entitled to an evidentiary hearing. As far as Lofton goes, I agree. There's no constitutional or automatic right for someone who's developed a relationship, because these children can develop relationships with 2 or 3 families or relatives. But you have to review them all. That's what ID says.
What do you think the preclusive effect is of the affirmance of the prior order of removal? Presumably there had to be, there was a contention that there was some problems with the placement. The department removes the child, your client objects. The court says, no, I'm going to remove the child because maybe the eye problem was self-inflicted, but the other problems definitely were not.
Okay. Let me answer, because I can answer very quickly, Judge, that what happened in that situation was pre-TPR. The rules are different, and this is something that's wrong with our law, frankly, that the department has the absolute right to take a child and do anything they want with that child prior to TPR. So she wasn't governed by the same standards. Post-TPR, when someone's filed an adoption petition, they're then governed by 63.022 and 39.812. 63.022 says that the best interest must control in every adoption, and then 39.812 even has a new amendment that was put in that said if a child has been living in a foster home for 6 months and has applied for adoption, then you can't remove him. because it's an automatic removal before TPR. The department basically has custody. It's their kid, you see. So I don't think that there's any preclusive effect. It's a completely different evidentiary standard. At this point, you have to look at what's the best thing for this child. And go back to my example. Say he'd been to 50 different foster homes and never thrived, and the department wanted to keep moving into other foster homes. Under this view of the law, he would never have the opportunity for an evidentiary hearing. I'd like to reserve 1 minute because there's one thing I want to add at the end, if I may.
Okay, you've got a minute left.
Good morning, may it please the Court. I'm Ralph McMurphy for the Department of Children and Families. And I would also like to state that just as Mr. D'Amico was a counsel in the IB case, I was counsel in Buckner. And this Court...
So you're the responsible party for the bad law that Mr. D'Amico is talking about? Just kidding. Just kidding.
Well,
it was that Judge per curiam.
If it's bad law, this Court has since adopted at least 3 cases that I'm aware of, including the prior appeal in this case, which was an appeal from an order not only saying that the department was correct in removing the child, but also stating that finding as that it was not in this child's best interest to be placed in Ms. Civic's home in a pre-adopted placement. And it was not even in the children's best interest that Ms. Civic be even allowed to be a participant anymore. She had been a participant because she had been a foster parent.
How do you square our holding in Buckner and the argument that you're making today with the fairly broad language in Chapter 63 about adoption? You know, any interested adult can file an adoption petition, something like that.
But you also have to square that with the requirements of Chapter 63 about what has to be in an adoption petition. And then one of the requirements that has to be in an adoption petition is that the person has to state when and from whom the person gained custody of the child.
So your argument would be that that pleading requirement mandates that only people with custody can file adoption petitions?
Only people who have been given custody in a pre-adopted placement, because otherwise you would be opening it up to, you know, anybody who happens to gain knowledge about a child. You know, some court clerk sees a child during a dependency case and thinks it's a cute kid and would like to adopt him, or somebody who works for the Guardian Ad Litem program, a child's teacher at school. You know, you're opening it up to anybody.
So your argument, though, if I understand it, is that unless you have physical custody at the time you file the petition, you can't file the petition. You don't have standing.
That's correct.
So if the department, for whatever reason, if the department, if I'm the foster parent, I've got custody of the child, you know that I'm going to file a petition next week for adoption. For whatever reason, the department doesn't think that's a great idea. In an effort just to prevent me from even having standing, you come in and remove the child right now. So next week I can't file. I mean, is that what you think the law is?
Well,
It would allow the department to essentially deprive me of standing by simply snatching the child from me, which you have almost the unfettered right to do in a dependency situation.
well, Your Honor, there would be no one in a case of a child who has been, parental rights have been terminated, and the child has been committed to the custody of the Department of Children and Families. There is no one who could have custody unless the department had placed that child there in a pre-adoptive placement, because upon termination of parental rights and commitment to the department becomes a legal guardian of the person of the child and entitled to determine where that child is going to live.
I'm with you. What you told me, though, was because the statute requires you to plead how and when you got custody of the
Yes.
child in your adoption petition.
Yes.
Your argument is that unless you have physical custody of the child on the day that you file your adoption petition, you lack standing.
Yes, because
So I guess my question is, if the department, the day before I'm going to file my adoption petition, decides, you know, we don't want to have to slug it out with old Judge Orfinger about whether this is in the best. We're just going to cut him off at the pass, deprive him of standing. We've got legal custody of the child. We'll just go in and remove him from the home today.
well,
Which you pretty much have a right to do. Well, there's some limitation under the new statute.
but they wouldn't be in that person's custody at that point unless the department had made a pre-adoptive placement, which is required under the statute, so that the home visits and final adoption study can be prepared after the child has been in the home for, I believe it's 90 days. So the situation that you're talking about, Your Honor, just does not exist in the case of a dependent child, because no one would have custody unless the department had placed the child there in a pre-adoptive placement.
Well, but if the department did place the child in the home on a pre-adoptive placement,
Yes.
and for whatever reason changed its mind and removed the child, it's your position that as long as they remove the child before a petition is filed, there is no standing?
Yes, because under the statute, we are the legal guardians of the child's person.
But there's some limitations on your total control over who gets to adopt the child. Would you agree with that?
Under the addition to section 39.8112, I think it's 8112.4, yes. When a person has applied to adopt to the department and has then has requested an administrative hearing and then can show that the department's consent is being unreasonably withheld. But
your position is they won't have a chance to come into court and argue if it's being unreasonably withheld if you get the kid out of there before they file the petition. Then they don't get a chance to say you're withholding consent unreasonably, because your position is they can't come into court at all, right?
that provision of the statute applies in very limited situations where, but you know, the only time that we would do that is if, say, we placed a child in the home and we found out after the home visits and all like that by the report that this adoption was not going to work, it's not going to go forward. But we don't place children in pre-adoptive homes willy-nilly. So the likelihood of that situation ever coming up is remote.
Does the petitioner in an adoption proceeding have to ask for the department's consent before they file the petition? Is part of the petition an allegation of whether or not the department has given them consent?
Yes, they have to determine. You know, they have to allege that they have that the child is free for adoption and they have all the necessary parties have consented.
Okay, so it seems to me from what you're arguing, the department could put itself in a position where it would never have to go to court to defend against an unreasonable withholding of consent, because if the petitioner comes to you pre-petition and says, can I have consent, and the department decides they're not going to give them consent, then all the department has to do is say, no, we're not giving you consent, and by the way, we're picking the child up today, and you'll never get your day in court. Is that
No.
theoretically possible under your position?
No.
Why not?
Because, under 39.812.4, if the prerequisites have been followed, and department unreasonably withholds consent, the dependents court has jurisdiction to determine whether consent is being unreasonably withheld.
Even if the child is no longer in the custody of the petitioner at the time the petition is filed?
Yes.
Okay, so you're backing away from your previous position, which is unless you have custody on the day of the petition, you don't have standing, right?
Well, in that situation, the consent would have, the dependency court would have overruled the department on the question of consent.
But they can't get to that question unless the petitioner has standing. And I'm hearing two different things from you. One is they don't have standing if they don't have physical custody on the day they filed. And on the other hand, what they can come in and argue that the consent's being unreasonably withheld. Well, how can they do that if you're saying over here they don't have standing in the first place?
Well, where they argue with the consent's being unreasonably withheld is in the dependency court, which is the court that has to approve the adoption, finalize the adoption. The reason for that requirement is that under Chapter 63, only an adoption entity as defined in that statute can make a pre-adopted placement of an unrelated child. And adoption is solely a creature of statute, so you have to follow the statute. There is no common law right of a court to create an adoption, to effect an adoption, because that's solely a creature of statute. And therefore, you have to follow the requirements of Chapter 63. You know, and they.
Mr. McMurphy, you've lost me. Help me out here. Yes or no? Standing is governed by whether you have physical custody of the child on the day you file your adoption petition or not. Is that the department's position? So they never get to look. Okay, let's just start with that. Does a party have standing if the department removes the child today? Does the party then have standing to go in the next day, tomorrow, and file an adoption petition?
Under the statute, the legislature determined no.
So they never get to argue whether or not the department's refusal to allow adoption was unreasonable or not.
They would be able to argue that in the dependency court.
In what proceeding? If there's not an adoption, what proceeding do they get to argue about the unreasonableness of the adoption refusal?
In the dependency case.
Well, how is the question of whether the department has unreasonably withheld consent to adoption an issue of relevance in any case other than an adoption case?
because the legislature has determined that the dependency court finalizes all adoptions, and the dependency court has jurisdiction over the child, and the dependency court can, if determine that the department's consent has been unreasonably withheld.
All right, let me ask you this. I come to the department, I've got custody of the child, pre-adoption custody. I come to the department and say, Department, would you please consent to the adoption? As Judge Palmer said, the department says, no, we won't, and hand over the child. So now the department has refused, and I don't have custody of the child. What cause of action do I have to litigate the unreasonableness of the department's position if your argument is I don't even have standing to file an adoption claim?
You have a route through the dependency case if the prerequisites of 39A12.4 have been complied with. And to argue to the dependency court that consent is being unreasonably withheld. And since it is the dependency court that has to make the final decision on the adoption anyway, the dependency court could do that.
Well, let's turn back to the specific facts of this case. I know there was an allegation in the adoption complaint that said that the department is unreasonably withholding its consent. Is there anything in the record that indicates that the department's consent was ever requested, or was it simply an assumption on the part of Mr. D'Amico's client that if she asked, the answer would be no?
Consent was never, she never asked for consent to the adoption. And maybe because she assumed that after the trial court had, the dependency court had found that the child was entered in her home and that we were correct.
Well, I guess my more specific question is, did the case ever get to the point of there being anything in the record that would suggest that consent was never requested? It seems to me that you can't unreasonably withhold it if you never are asked. But my question is there anything in the record that would suggest that the department was asked for consent and said no?
No, there's nothing in the record to establish that. And because the situation had never arisen where she could have, would have been appropriate for her to ask for consent.
Well, your contention is she didn't have standing.
Yes,
And so, again, I got to tell you, I'm having a little trouble with your whole theory on this circular argument about you don't have standing and so you can't get review, but you can get review someplace else in the dependency court. I've got to go back and draw myself a map to figure out your argument on that one.
It's the department's position that requirement under section chapter 63 about the petition having to say when and from whom the person gained custody is not a question of standing. It is a question of a legislative requirement for to make sure that the court knows that the proper procedures for the placement of the child have been followed, and that the person who's seeking to adopt has had custody of the child long enough for the pre-adoptive study to be completed, because that has to be done while the child is in the home of the proposed adopted parent.
Couldn't a petitioner provide that information even if they didn't continue to have custody? And couldn't the petition say, I received custody from the department on such and such a day and had custody until such and such a day? Doesn't that meet the statutory requirements for what has to be in the petition? Or does the statute say you have to allege that you have continuing custody as of the time you file the petition?
Well, it states that in order to adopt, to file a petition for adoption, you have to state where and from whom you got custody of the child for adoption. I mean, we're not talking about...
They can do that if the child was placed for pre-adoption, even if the department changed their mind, right? They could allege in their petition, I got it from the department on a pre-adoption placement on this day, and I had it until this day when the child was unreasonably removed and the department unreasonably refused to consent to the adoption.
They could allege that, and if the dependency court could then determine whether it was an unreasonable removal. But in this case, the dependency court had already determined that our action was entirely reasonable, and that this court affirmed that decision. And the dependency court, in an effort to prevent just what happened here in the earlier order in August 2004, determined on the merits that it was not in the best interest of the child to be placed in Ms. Civic's home in a pre-adoptive placement. That finding was affirmed by this court, and so she has had her best interest hearing in 2004. And this child has not been in her home since he was removed 2nd or 3rd of October 2003.
Mr. McMurphy, I can't recall if it was this case or another case, because sometimes the facts go together a little bit. Did somebody file some supplemental information, or was it in the briefs that indicated that after the adoption petition was dismissed, that the child has subsequently been adopted by someone else?
Yes, I received from our Ocala office a copy of an order closing the dependency case because the children had been adopted. This child and his sister had been adopted.
Thank you. Your time has expired, Counsel. Counsel, we let opposing counsel run over by 2.5 minutes, so I'm going to add 2.5 minutes to your time, so you've got about 3.5 minutes.
Well, I appreciate that. There is one thing I want to discuss that doesn't necessarily go to the lively discussion we've been having today, but I know how appellate courts have to limit rulings to very precise issues and rules of law, and I know how, you're always looking for a way to dispose of a case. But in this area of the law, which I have been practicing in about the last 10 years, we need some guidance. In all honesty, attorneys don't understand the difference between Buckner and IB, and honestly, I don't. I know that you all, it's something that's more obscure. What we need some guidance. We need some rules so the trial court will know exactly what to do. These adoption proceedings are so sensitive. They put children in people's homes, and they bond to these children. The children bond to them. And no matter what they say, when you come and take a child away after 15 months, 16 months, 2 years, there is trauma. These adoption proceedings need to be decided at the trial court level and not at the appellate level. You know that the appellate court is not the venue to be in. It takes a year for an appeal to run its course, and this time a child is going through placements.
Counsel, then you would agree that the trial judge is in the best position to be able to determine what the manifest best interests of the child are.
Yes, and the thing is, and I agree, but the trial court needs to know what to do. There have been 3 cases in the last 2 years, IB, Buckner, and this case, where trial courts dismissed adoption proceedings. Now, in IB, it was reversed. In Buckner, it was affirmed, okay? I mean, and in this particular case, the trial judge denied the motion for summary judgment, said on the record, this is a best interest determination, and then the day before the hearing, I told you this before, she wasn't clear what to do. And when I argued the ID case in front of Judge Breeze, that it's on the record, you can go to the clock, he said, I'm sure I'm right in this case, I'm not getting reversed, okay? And he got reversed. So, you see, we need something where everyone knows, like, what is the standing? We've talked about the standing question. What have we got to lose?
Let me ask you this, counsel. In addition to alleging unreasonable withholding of consent, if you otherwise have standing,
Okay.
do you think there's a requirement if the child is no longer in your custody to allege that the removal was unreasonable? Is that one of the, I mean, if the child is removed from you, do you then have to establish that it was an unreasonable removal?
I don't think so, Judge. And the reason I don't think so is, go back to my example. Let's take, let's say the department, when they took this child away, they were well-intentioned. You know, they thought something had gone wrong, that my client maybe had done something wrong. They were well-intentioned. But then, as the guardian ad litem's affidavit says, the child, they were unable to place the child in a better placement. They were unable to get him back on board. I mean, if you read this affidavit, it's only a 2-page affidavit. It's in the record in the affidavit in opposition to the motion for summary judgment. Thrived in the child in the civic's control, wants to be adopted, has regressed after being removed from the civic home. These are so what does it matter what the reason was? What matters is what is in the best interest of the child at the time of the adoption. I just wanted to conclude by saying the other problem is the legislature hasn't made it extremely clear either. And we need something. We really, truly need something so you can cut this off, that there's a best interest hearing for everybody that's concerned.
How do we deal with the allegation that this child has now been adopted?
Well, you know, they did that at their peril, as far as I'm concerned. I mean, they knew about this proceeding. The department see, we don't know anything about that proceeding. We were just sent a notice that said that they've closed the proceedings because of an adoption. We would have to file under one.
But wasn't one of your arguments in your case related to the unadoptability of this child?
Well,
doesn't that go out the window even if...
It would go out the window to the extent that if you're looking at this particular case, but you've got to look at it at the time of the appeal, at the time that the appeal was filed, to come up with a good rule of law. Because there are going to be 10 cases that come after this where the child is not adopted. And the child will linger in that gulag of foster care when he should be adopted by someone else.
But if our concern is with the best interest of the child,
that's what I'm asking you for.
If we all agree that that's the concern, how is the best interest of the child served by now 2 years after the fact, reversing the decision here, and now we've got a final adoption from apparently the circuit court someplace else? What's the, are we supposed to say, okay, go snatch the child? I mean, what's the practical effect?
I understand. I mean, it was the same thing that you said before. The department, all they have to do is say, we're just going to take the child away, so therefore you no longer have any standing, okay? It's the same kind of thing. We'll just go get the child adopted by someone else, and then that's the end of it. I understand my client has a hard road. Believe me, she understands she has a hard road, and I honestly...
Well, I guess my concern, though, is, it's not like a piece of property where you have a lis pendens on it, and if I buy a piece of property with a lis pendens on it, then I know that I'm buying something that arguably has some issues.
Okay, but what I'm saying is, no matter what comes out of this case, we need the guidance, and however it goes, and if that's what the decision ultimately ends up being, my client's not going to be happy. She knows she's got a hard road, but we have to know for the future. And if you look at this case, because you're looking now at an extra record situation. What you're talking about now, something that has nothing really to do with this appeal. But I understand the practicality of it. We do need some guidance. The Supreme Court has said if the consent's unreasonably withheld, we've got the right to file adoption petitions.
Let me just ask you one question on the consent. As part of alleging that consent has been unreasonably withheld, do you have to allege that we asked for consent and it was unreasonably withheld?
Unfortunately, part of this probably isn't in the record, because usually it's done by letters. You write a letter to the department and you ask, and in this case, whether the letter was written or not, I mean, they're here, they've opposed her all the way through, so.
Oh, but again, I'm just trying to understand, if, we all agree that there's a requirement, that, you know, your petition either has to say that the department has consented, or the department has refused consent.
She would have loved their consent, Judge.
I'm with you. I'm trying to understand from simply a pleading perspective.
Right.
Do you have to say, is it enough to simply say the department has unreasonably withheld consent if you don't also say we asked for consent?
Well,
In other words, can they refuse something if they're never asked?
I understand, but in this case, it obviously wasn't going to be consented. In most cases, we usually ask, and the department will usually say no if, you know, we know it's going to be no, because we know what their position is in the case most of the time. But if you think that that's a requirement, but the point is that if you just allege it's being unreasonably withheld, and the department says, well, we support this adoption, well, then you'll get the consent from them. You see, so it's kind of an issue that, the most important issue is to get a best interest hearing, and if there are 2 or 3 people that are interested, and I've had trials like this where we've had 4 different parties, all a grandmother, a cousin, an aunt, an uncle, 2 foster parents. The judge hears everything, and he makes a decision on the adoption. And you all know that's unappealable, because it's a fact question. It's not going to be a legal question. But you've got to give us the rules, because nobody knows what to do between Buckner, IB, and BY. And so I'm just asking you for the good, that we can save some other kids from going through this. You saw what happened in the IB case. The IB case is exactly the example that appeals don't help. We have to have rules for the trial court, and that's what I'd ask at best to come out of this case.
Thank you, counsel.
Thank you very much, judges.
Appreciate the arguments from both.